Well, hello, everyone. I've already introduced you to our next two speakers. I'm really happy to be with Joe Durker and Ron Miller, both lawyers practicing in Saskatoon, and really much appreciate each of you. Ron, thanks very much for being here, and Joe as well. Uh, we're, of course, talking about the test, the second test in the four-way test, which is it fair to all concerned? And I think we would all agree it's hard to be fair sometimes to all concerned. We have our self-interests, we have our loyalties, we have our own view of things. And so for any Rotarian, that's going to be a challenge. But I would think that among the most challenged people in that vein would be lawyers, because lawyers, of course, have a duty to represent one side of something. And a lawyer who is a Rotarian must feel a real tug between that duty and the duty that he or she undertakes under the four-way test to be fair to all concerned. So, gentlemen, that's what I want to focus on in our talk. And I'm going to start out with a quotation. And then, Ron, I'm going to come to you with a question. And the quotation is this, and I've taken this is an excerpt out of the Lawyer's Professional Code of Conduct, and it reads as follows. In adversarial proceedings, the lawyer has a duty to the client to raise fearlessly every issue, advance every argument, and ask every question, however distasteful, that the lawyer thinks will help the client's case, and to endeavor to obtain for the client the benefit of every remedy and defense authorized by law. The lawyer's function as advocate is openly and necessarily partisan. Accordingly, the lawyer is not obliged to assist an adversary or advance matters harmful to the client's case. Now that sounds like a pretty one-sided set of duties. So, Ron, you've been in practice for how many years now?
I've been practicing, it's getting close to 40.
Okay, so you've been around the horn a few times, and you are not currently a practicing Rotarian, but you have been, and so you know about the obligations of Rotary. And I'm just going to ask you this question. Suppose you're sitting in your office, you're a Rotarian, you have the four-way test on your wall. Client comes in, reads the four-way test, and gets to the second point and says, is it fair to all concerned? And the client looks to you and says, is it your intention to make an effort to be fair to all concerned when you're representing me? I'm hiring you to represent my interests, and I'm not paying you to look after anyone else's interests. Should I be looking for another lawyer? What would you say to that client?
Thanks, Jim. That's an interesting question. I think what I might do is just sort of give a bit of background that might help explain how a lawyer fits into this and would view their role. And that may assist in sort of the answer that I would give to a client if I was asked that question. So I'd answer sort of it this way. So the starting point for lawyers is that we're retained to assist clients, be they individuals, companies, organizations, entities, make decisions and comply with their obligations under our legal system. Sort of basically the rules that we've chosen as a society that will govern our dealings with each other. So that's what lawyers' role is in that. We individually and collectively, lawyers, are part of the judicial system. We're one part of it. There are really three components to it. One is the lawyers, the independent bar. The second is our legislative bodies, parliament, provincial legislatures, local bodies. And the third is the courts. So each have a role to play, and lawyers have a role to play. So even though I have an obligation to assist that client to the best of my ability to advance their cause, as outlined in the quote you gave, there's other obligations upon me and other lawyers in terms of what we can or cannot do. So my duty to my client is qualified by these other duties and obligations I have to the court, to the public, to other lawyers, to the community I live in. Our law society, as is every law society in our country, has set those out in a code of professional conduct, which guide us and give us rules that we are obligated to comply with in the performance of our professional duties to our clients and others. And that code qualifies that statement that you've just given. And what it says is that a lawyer is required to discharge that obligation you've outlined by fair and honorable means, without illegality, and consistent with the lawyer's duty to treat the court with candor, fairness, courtesy, and respect. And so you'll note that fairness is built into that. And it goes on to say the lawyer must at all times be courteous, be civil, act in good faith, and at all times carry out or perform in that way in all of its dealings. So underpinning all of this is what's called the duty of integrity. And that really is, to my mind, what goes to the duty of fairness. So when I'm speaking to a client and they ask about fairness, I would explain to them, well, I have a duty under the Code of Professional Conduct to act with integrity. That's in your interest as a client, because you also will be well served by the judicial process by acting with integrity, and I'm obligated to do that. So what is integrity, right? And what's fairness in terms of assisting a client advancing their case? It's not to sort of move away from or give up your client's rights or entitlements because you personally think that might be fairer to the other side, but rather it's sort of the obligation to act in accordance with sort of the soundness of moral principle, truth, fair dealing, candidness, honesty, sincerity. So that's really integrity, which I think aligns very closely to what most Rotarians would consider the duty to be fair to be all about. So that code of professional conduct I talked about has got 22 chapters in it, all of which are underpinned by that first rule, that duty of integrity that I just talked about. So that's our obligation. That duty of integrity obligates me to advise the client that although I'm there to advance their case to the fullest extent possible under the law, I have to do it in accordance with the various duties that are placed upon me by the law society and the justice system. And that those duties, although on initial view might be considered to be in conflict with that duty to the client, they really are to the benefit of the client because it will result, generally speaking, in a better outcome, in my view, to that client. So that's a long way to answer a short question, but that's what I would say to the client, perhaps in a shorter form, that I've got professional obligations to you. I'm a member of the legal profession. Acting with integrity, acting with fairness is in your interest and in my interest, and they're not in conflict in terms of what I would hope to do for that client.
Well, thank you for that. And that's a very thorough and considered answer. So integrity, as you say, is at the foot of it all. And I understand as well that lawyers are part of what we call a self-governing body. What does that mean to lawyers and how they conduct themselves?
So going back to what I said about being part of a profession, which is part of our legal system, we're self-governed. So in order to practice law, you have to be a member of a provincial law society, which is a self-governing, self-regulating body, and you have to comply with your obligations under that society to continue to practice law. And those obligations include this code of professional conduct with those 22 chapters in it. And if you are found to breach them, you're subject to possible complaints to your governing body, a disciplinary hearing, and in the most severe cases, you could be disbarred or lose your license or ability to practice law.
So there is then, like the average citizen, of course, is governed by the laws of the country, but the average citizen doesn't have an additional concern about losing their livelihood or being called to a review of their peers. The lawyers do have that, of course. So lawyers have that, and of course, lawyers also operate under rules of court, as I would understand, where judges can impose fairness even if the lawyer and the client are not observing that in the way that they're conducting their case. So you've got all these additional, or I would say we have at least two things as lawyers which average citizens don't face, and that is scrutiny of judges and scrutiny of our peers as professionals. Would you say that that the duty to fairness is controlled by these three forces for lawyers, or is it possible to be in compliance with all of these things, not be offside the law, not be offside the rules of court, and not be offside your professional obligations under the code, and yet still have an opportunity to be unfair, if I could put it that way? Is there any slack in all of this?
There's always sort of grayness in most things, and I guess the issue would be how you define fairness and what that means in terms of the legal system, the court system, the professional obligations of a lawyer, in comparison to what fairness might be understood to mean under the Rotarian four-way test.
Mm-hmm.
My view is they are, for the most part, consistent, but there's always sort of some subjectivity in terms of how one individual might view fairness as opposed to another individual. But I think that's there in terms of the application of the Rotarian test, and it's there in any other principle. But I do think that the design of our court system, the sort of the structure of it, is to result in a fair outcome for all parties. And fairness, I think, in the legal system is defined by an outcome that is considered just under the laws that we've chosen to govern our society as we interact with each other.
Right. Okay. So just a parting question then, and that is this: if this client that I hypothesized at the beginning says to you that they believe that there's a course of action that you should help them follow, which complies with the law, is not going to be sanctioned, and you're not going to be sanctioned, and yet you don't feel it's fair, how would you handle that situation?
Well, I have an obligation to advance that client's interest to the best of my ability. If the client has a different view in terms of how they would like their case to be advanced than I do, and I find or feel that that would impede my ability to act in accordance with that client's interest, again, assuming that there's nothing inappropriate or unfair in that client, really my obligation then is to advise the client of that and either make a decision on my own not to accept a retainer, or work with that client to find a mutually acceptable approach to that issue that both the client and I are comfortable with.
Okay, well, thank you. That's been a really thorough look at a difficult set of questions. So, Joe, I want to turn it over to you now as our elder statesman here. Joe, how long have you been in practice?
This year it's 61 years.
Okay, well, that's remarkable. Is there any end in sight for you?
Is there any which?
End in sight for you.
There's always an end in sight.
Well, Joe, I wonder if you could, you're a Rotarian, you currently are, and have been a Rotarian for a great many years, and you have had a lot of opportunity, I would guess, to come in view of the four-way test and its obligation to be fair to others, and your obligations to your clients, which they may not always see as being in line with a duty of fairness to others. How have you addressed that in your practice?
Well, it would be helpful, I think, if I describe briefly what I've done over the last 61 years. I have been involved in construction operational agreements that were in the hundreds of millions of dollars, major international financing and banking arrangements, and also much more humbling to me in the sense of my ability to communicate the person coming in to see about a rental dispute with that person's landlord. dealing with fairness to that person in that situation. That is in many ways the greater duty that I have found and the greater difficulty. I'd like to build on a few things that Ron said. Ron addressed fairness to the courts. Many of the people listening to you, Jim, will have seen the Michigan case of about 2 days ago, in which the Michigan judge kicked out of court with penalties persons who were applying for the defeat of the American election, and who, as lawyers, took affidavits that were totally improper and fined them and referred them to the Law Society for further attention. I think that that will give people some understanding of the duty to the court that Ron touched on, which is fairness and honesty. Now, Jim, the last time I was in court was perhaps before you were born, in 1965. It was a case that I, with my eloquence, prepared responses, etc. And at the court, the judge took great sympathy to the defendant, took it upon himself to amend the pleadings, which resulted in my not having provided evidence of compliance with the new pleadings. So that is one part of answering your relationship with litigation as distinct from other. Jim, there are a couple of things that immediately came to mind when you told me that that was going to be the question. You will remember Cal Tallis, who became one of the best Court of Appeal judges in Saskatchewan. I was at a group session with Cal, and his comment on litigation was this. He said, the worst settlement that you can arrange with your client, for your client, is better than the best litigation. What he was really saying is that you have a duty as a lawyer to get parties to come to an understanding of the interests of either party. I mean, that was paralleled by a taxi driver in Cologne when I was negotiating an agreement in Germany. The taxi driver on the way asked me what I was doing, and I said I was here to do some agreements. He said, Sonny, there is no agreement that will stand up unless there's something good for both parties in the agreement. And that's absolutely correct. I have found over the years, Jim, that there's got to be an entering into a commercial relationship with the expectations of both parties right on the table, so they're known, and that there is a clear understanding of the expertise of the lawyer in documenting those expectations. In the absence of discussions and the lawyers on both sides taking their clients, preferably at group meetings, into the wants of each party and the long-term expectations, then you're bound to have problems. The next thing I have found, well, I must back up one step, Jim, here, please, because in learning the expectations, I have found that one of the most important things is to listen to the lawyer who is acting for the other client. Because despite the fact that you and I are the most intelligent people in this room, except for Ron, we have different views on how we should do things. You and I have had enough discussions at Rotary and otherwise to respect each other's opinions. And that is exceedingly important in commercial transactions and in other relations as well. Now, as a lawyer, you've got to recognize that despite your best efforts, disagreements are going to happen. They're just going to happen. And so as counsel, you really do owe it to your client to talk to your client and make sure that parties agree on the how the waterfall of steps that you must take to resolve the issues. And the first one is to have provisions for organized in-party meetings. That's the best way. Then you go to mediation, ultimately to arbitration. And I rarely recommend litigation. Ron can speak to that. That's more his area. But I have found that this waterfall of steps has worked well. An interesting event, Ron, and it tells you that you have to be aware of cultural differences. So we have the agreement with a Japanese company for the supply of major production equipment. Disagreement on its functioning. What I learned to my amazement that when you go to negotiations with the Japanese on the other side, you start by both parties bringing a gift to the other. So we took and we got some Eskimo carvings, and that was our offering to the people on the other side as part of our good faith, that we were coming in good faith. And of course, the same on the other side. Now that was a practice that I experienced. Does it exist in today with internet taking over? You know, I don't know, Jim, but we've certainly found that was the best way to do that. Okay, when you think of fairness, Jim, in structuring business relations, it's important that we think of this in the terms of the disclosure that you would expect for a fairness opinion. Have you really been honest in the estimates of your business? Have your expectations of profitability, have they worked out? And as you know, the courts have moved into a very careful review of expert opinions to make sure that when the deal is completed, there is a fairness in the parties accepting it. Think of an offering memorandum for the shares that you own in your wife's company. What do you have to tell about that? Even though she keeps secrets, Jim, it's your obligation to disclose. Okay, you and I know that. Okay, Jim, I think the other big area that I have experienced, Jim, is the failure to keep your client informed. The only way that you can serve a client is to have the client walk step by step with you in the structuring of the arrangement, but more importantly, in the structuring of how you're going to unwind what you're in if you have to. And so the importance of communication initially is self-evident. The communication when there are difficulties is perhaps even more important. What are you going to tell the client? You are the person that drafted the agreement. Other people have said it doesn't express the view, whatever the issues are. And this goes back to Cal Tallis's comments, solving that by discussion and settlement has to be the answer, particularly if you have an ongoing relation. I mean, you can't have an ongoing relationship if what you've done is set up an issue that cannot be resolved in their commercial relations. Jim, I've taken up more than my allotted time, but you've got to give me 1 minute to talk about the pro bono services provided by the Law Society. The Law Society gets lawyers, and a number of lawyers. Jim and I will have participated in this. And we agree to provide services to people who are on social welfare, basically. We get a brief from social services. We then take and communicate with that person by phone. Jim, it is soul wrenching to deal with these people. So I don't have any problem in drawing $1 million contract, but how do you deal with a grandmother whose grandchildren have just been taken because the family can't afford to keep them or whatever the reason? How do you deal with it? I mean, it was the social shock of my life, including the work that we had done in Rotary. And it is a service that is not well known by people who look upon lawyers in many cases as not being accountable. And this is something that Jim, you're trying to bring forward to our group here, and that is that the legal profession, lawyers as individuals, are personally committed to fairness in the better way that we can for social structures.
Well, thank you. Just as a closing comment, because time is at an end here for us, but thank you for all that. But I wanted just to reflect on one more point about your experience with the pro bono services. If I heard you correctly, tell me if I'm on with this, that finding fairness, you found more difficult perhaps dealing with these kinds of circumstances than you found in your commercial experience with, as you put it, multi-million-dollar deals. Is that fair?
Jim, you and I are so far out of that field to take, we read the stories in the Star Phoenix about homelessness. We read, you and I have been on how many projects in Rotary to provide financial support to the Métis organization, the drop-in center, whatever. We've done that. I've been a member of the Rotary Club since the 60s, and we've had many of those. But dealing on a one-off basis, I had to deal last week with a situation where the family basically took the assets through powers of attorney that the father had given, and he was basically left without assets, and he's supposed to live on social services. Those are the types of questions, Jim, that the public doesn't realize that come to the lawyers. And I can't tell you the number of nights that I haven't slept. It was more than I could handle.
So fairness is difficult for all of us, is what it would come down.
Oh, absolutely.
Well, gentlemen, we have come to the end of our time, but I want to thank you both so much for the thought and effort that you've put into what we've talked about today. I know that your messages will raise a lot of questions, and you are about to find that out now, because you will have questions coming to you from our audience. So good luck with those, and thank you again so much. Again, we greatly appreciate the time that you spent with us. Thank you.
Good, thanks, Jim.
Thank you.
My pleasure.
So there are no questions yet in the chat box. If you do have a question for either Joe or Ron, would you please type it into the chat?
Nobody can find the chat box, apparently.
I think both men gave such a good précis of what it means for lawyers to be fair to all concerned, that that there are no questions. It's very well understood by your presentations. So we do thank you for that. And if there are no further questions, maybe Jim will hand it back to you. Okay, we do have a question from Elaine Thompson, Charleswood in Winnipeg. How does the legal system compare between the Canadian and American systems? I really don't know if we have the time to answer that one, but do one of you want to take a crack at it?
Well, my experience has been in many areas of the United States, and particularly in England and the jurisprudence that comes out of that. In Canada, we also have the civil code, and my experience there has not been significantly great. But you will find there are a lot of technical difficulties, but you will find that the principles of the practice of law are almost identical. I was hoping that somebody would ask a question so I could expand on my few comments about the Michigan case. Some of you may know it as the Cron issue, the question of bringing before the court in Michigan all of the applications throughout the election built on very fraudulent, not very careless, and in many cases fraudulent affidavits. And Jim, there was a good summary of that, just if you want to follow it up, in the Globe and Mail today. But there were 4 principles enunciated by the judge. And it was this. Now, I'm sorry, is something ringing? Okay, first, lawyers are required to act with basic competence. They must understand and take it upon themselves to understand the issue and must have the ability to practice that area law. Number 2, lawyers must not assist clients in conducting what they know is a fraudulent transaction, or at least suspected. Number 3, lawyers are prohibited from filing claims without merit. And just to build some flesh onto that one, the practice was to fill the courts up with these claims so that the courts were tied up from doing other things. And then 4th, it is professionally important for, can't read my own writing, it is professionally important for lawyers not to do anything prejudicial to the administration of justice. And the important override is that while lawyers have private duties to their client, they have an overbearing duty, public law duty to society. I hope that helps.
Thank you very much, Joe. We don't have any other questions in the chat. I echo Gail Marie's congratulations on covering it very, very well. And so we'll move on to the next portion of the program.
Well, Rotarians, we are now welcoming David Katesman. David, as I've told you, is a mediator with the Saskatchewan Human Rights Commission, and David's current professional activities involve bringing fairness to situations where that may be lacking. So David, welcome. Thank you so much for agreeing to spend some time with us this evening. And we're just delighted to have you here. So I'd like to just get started with what we've been talking about. As you know, this session relates to one of the components of our Rotary Code of Ethics, the four-way test. And that test that we're talking about tonight is it fair to all concerned? Now, fairness is your business in mediation. And as you know, we Rotarians want to be fair, but fairness can be a challenge, particularly where there is either a divergence of interest or a dispute. Drawing on your experience, could you tell us what you see as being the most significant bars or impairments to mediation and fairness, bringing fairness to mediation?
Well, first of all, I'll say a couple of things. First, I'm so pleased that I was invited. Thank you. And how commendable it is that the Rotarians want to promote fairness throughout their lives. It's not something you teach 10-year-olds. It's something that we all need to keep thinking about and striving towards. And I want to mention mediation cannot impose fairness. That's arbitration or some other hearing. But I want to have a fair exchange of ideas and thoughts and understanding. Quite often there is a power imbalance between two persons or more persons in a mediation. If you think of someone who is very articulate, a skilled listener, pretty smart, that person is a heavyweight. And we know that in any discussion or conflict with that person, they're going to hold their own or are likely to prevail. And there are many persons who come for mediation and they really have difficulty creating a coherent presentation of a chronological set of facts. And they're not good at listening. As the other person is speaking, they're already preparing their answer to that person's first point. So they miss the second and the third point. So they're not good speakers. They're not good listeners. And let's face it, some people are just faster than others in stringing together their thoughts or in understanding other people or finding flaws in other person's presentations. So I like to think of myself as the person right in the middle of a teeter-totter. It's not very comfortable right there with that iron bar, but you're standing right there. And on one side, you have someone who's a heavyweight. And on the other side, you have someone who is perhaps not so much. And so pretty quickly, they're not seeing eye to eye. And my job as mediator is to try help them see eye to eye so that they can hear each other, so that they can express themselves coherently. And practically, that might mean assisting one or both or all parties to get their thoughts down in point form on paper so that they're not struggling during the mediation to remember significant facts. I help people to listen by insisting upon a very civil environment. It's pretty hard to listen carefully if you're being berated. So we keep things at a conversational tone. And sometimes I will summarize. That's where you get those very annoying catchphrases that we all hear from mediators. Let me see if I understand what you've been saying, or so on. And you summarize one side before the other side starts. And so you might say, well, I heard you say A and B and C. Did I get it right? Are those the three things? Well, I remember when we were preparing in our discussions, you had a fourth point. Oh, yeah, now they look at the piece of paper. Oh, yeah, there's the fourth point. And some might say that's helping the other person too much. But that point's going to come out at investigation or trial. Mediation is meant to solve things quickly and as much as possibly fairly. But I don't get to impose the outcome, which is another problem. You can have complainants who've been the victims of some horrible discrimination, and they don't know what a reasonable outcome should look like. They don't know, is this worth $1,000 or $10,000? And because I'm not a lawyer, I can't give them any advice on that point. But I can say, well, explain to me why your number seems reasonable. Why couldn't you go higher? Why couldn't you go lower? It's up to them to think of something reasonable. Now, I will say at the commission, there is a small bit of protection, because after every settlement is reached at mediation, a lawyer reviews it to make sure it's in the ballpark and we haven't missed something really important like long-term disability. So that's what I try to do in mediation.
So, what are some of the pitfalls that occur because of power imbalance? You mentioned that as being a situation that gets in the way or can cause trouble in a discussion that's where people are, even where people are trying to be fair.
You know, if someone comes from a really advantaged background, whether you win or lose this fight is probably not going to rock your world. But for the other person who might be coming from a significantly disadvantaged perspective, that $1,000 or $10,000 is going to be very significant. And when you're under that pressure, you sometimes get too emotional. So someone who has all these advantages, you're smart, you're articulate, let's face it, you are a person of substance. Can you empathize with that person? And instead of starting the conversation with, this is what I think is fair, and very nicely articulating all of that, start the other way around. I want to hear what you have to say. And then be patient, because they may stagger through their presentation. But if you listen carefully, you can understand what they're trying to get across. So when the deck is stacked in your favor, are you willing to unstack it a little bit to really understand the whole story?
Mm. Well, that leads to an interesting point, which is if you happen to be or find yourself as perhaps the stronger party in a disagreement, do you have to, just to be fair, do you have to give away what you really think, to some extent, what you would think would be fairly part of what you should come away with? Do you have to be a bit of a pushover if just because you have power on your side?
Well, I turn back to some pretty ancient writing on that. From the Hebrew Testament, you know that judges should not show favoritism to the rich or to the poor. So just because you are wealthy doesn't mean that you should just roll over and give away stuff. That's not good really for anyone. If you want to do philanthropy, that's another chapter, and I'd be pleased to talk about philanthropy. But in a conflict situation, that's not it. You should stick up for yourself. There was a Hebrew rabbi who was contemporaneous with Jesus, Hillel the Elder. And perhaps his most famous expression was, "If I am not for myself, who will be?" But the second part, "If I'm only for myself, what am I?" And finally, "If not now, when?" So really the third phrase doesn't apply to this discussion, but definitely you should, in the first phrase, assert yourself. But in the second phrase, if it's just pure self-interest, then what are you? I mean, the implication is you're not even truly human if all you do is care about yourself, which takes us to some interesting discussions about the difference between Canada and the United States, with the Americans having this individual's pursuit of happiness, perhaps to the exclusion of the Commonwealth. Where in Canada, I would like to think, and particularly in Saskatchewan, while you do have some self-interest, you're always obligated to think of what does this mean to everybody else?
Now, just I want to come back to that point because it points to perhaps different conceptions of fairness than what we might ourselves bring into it. But I want to just talk a little bit more about the power imbalance, because it seems to me that's an important point. What would you do as a mediator to address power imbalance? Are things that you would suggest that maybe we ourselves as Rotarians, if we're in that situation, could remember for ourselves if we find ourselves there?
Well, frequently in a mediation, the employer comes with a lawyer. The employee is unrepresented because the employer has the resources to pay for the lawyer. So right away, we've got 2 against 1. And the second person for the employer is a professional speaker and negotiator. They have brought a knife to a water pistol fight. Now, I would say that of the 200 lawyers I've dealt with in the past 10 years, approximately, only two have ever been aggressive. All the others, I would say, have either been quite even keeled, but the majority would start off a mediation by saying, first, I would say to the ex-employee or current employee, I want to thank you for being here. I want to assure you that we're here to listen to you carefully. And we care as much about understanding what you have to say as we do helping you to understand what we have to say. There's just this really gentle introduction. It must be being taught on campus. You know, at mediation, try to get them to calm down and feel good about themselves, because then you're more likely to have a productive, constructive conversation. So the number of people present can be one of the first barriers. An employer can say, well, I got to bring my manager, and then I got to bring his foreman, and I got to bring the lawyer, and pretty soon you got 4 on one side and 1 on the other. And that can be intimidating. It doesn't matter how old you are, just the physical numbers can be intimidating. We always start with the complainant speaking first, which is a bit of an advantage. It allows them to get started without, feeling put upon. And as I said before, I try to help all parties, but usually if an employer's got a lawyer, they don't need me to assist them in producing their thoughts. They're pretty good at it. It's the unrepresented employee who needs help just to assemble the main ideas. Quite frequently at the beginning, they've got 100 different things they want to say, and they bury the pearls that they have in a lot of sand. And so you're
in a situation where, sorry, just to cut into in a situation where you find yourself in a power imbalance and you're the one empowered, does it pay sometimes to suggest to the other person that they might want to get some help in order to better serve their own interest and in the interest of bringing fairness about at the end of the day?
Frequently, they will bring a friend or a relative who really is not much more talented than themselves. They would love to have a lawyer, but the cost is prohibitive.
So what are some alternatives then for them?
Well, as the Human Rights Commission practices mediation, I remind the complainant, if this doesn't make sense to you, don't make a deal. Then it will be thoroughly investigated. It might take 3 months, it might take 6 months, but at the end of it, you'll get a complete report. But more importantly, the chief commissioner and the lawyers will review it and they'll decide if your file merits going forward. And if it merits going forward, then a lawyer from the Human Rights Commission will become involved. The lawyer doesn't work for you, but the lawyer recognizes that the commission believes the law has been broken and will advocate for an appropriate settlement. So later on, there is access to a lawyer, but you need a very strong file to get a lawyer.
Now, I want to go back to something that you mentioned earlier. You were talking about the difference between Canadians and Americans, and that sort of put me in mind of a question, which is, as a now retired lawyer myself, I sometimes find myself looking to the idea that the correct answer in a problem is the answer that the law would provide, and theoretically, there's only one answer, and it's what a court would conclude at the end of the day. So there may actually only be one truly legal correct answer. But would you say the same is about fairness? Is there only one fair outcome to any problem?
Oh, absolutely not. The one that comes most readily to mind is comparing the North American approach to speeding tickets to the Scandinavian approach to speeding tickets. In North America, Jim, if you get caught going 50K over the speed limit on the highway, you're going to get fined, I don't know, $600. Now, I, as a lowly mediator, if I get caught with the exact same speed, I am also going to get fined $600. The deterrence isn't the same. Now, in Scandinavia, the fine reflects your wealth. And so one fellow was fined $130,000 for speeding. Now, regardless of your wealth, you're probably not going to do that again. And so, in terms of being fair, is the pain inflicted, which is meant to be the deterrent, is it equal? No. If you have someone who's quite wealthy, you hear of people who have summer cottages and they know the environmental laws. Who cares? I'll dump the sand on the beach. I'll go in and rip out those nasty bulrushes and I'll get fined $10,000. Big deal. I get what I want. Whereas for other cottage owners, $10,000 fine, that's unbearable. And plus, they've got a sense of this is not about the individual pursuit of happiness. This is about the collective pursuit to a commonwealth.
And so that sort of brings you back to the notion that there may be fundamental differences between societies and how they look at what fairness involves, and the same with individuals, I would take it.
Well, that's why it's so important to say to the other person first, so what do you think a good resolution would look like, rather than starting with your own? There's a greater possibility of understanding a different culture and a different set of values. I mean, I have worked with some people who made it very clear they don't want any money from this complaint, but they want some systemic change so that other people don't go through what they've experienced. And for other people, it's all about the money. So what you value will determine what you will seek as a fair outcome.
So there, I guess the bottom line might simply be this, that there is not necessarily the fair outcome, but what one should be looking for is a fair outcome among many possibilities. And you shouldn't be determined to get the only one that you have in mind when you start with.
Well, there's an old mediator training exercise where, somebody finds a room too warm or too cold. So what do? Well, you end up fighting over the heat controller, whereas one person could just move towards the window that's open and have a breeze. Like, there are often many roads to the top of the mountain.
Yeah, and the thing about the law, to bring back that for a moment, is that the law is very stilted in the way that it has to address things, and if you are involved in agreeing with people, you might find that solution about going to the window, which the law wouldn't recognize. The law would end up giving control of the meter to one person or the other, and thus perhaps not producing the best result of all.
As an outsider, it looks to me like the law says there is one route up the mountain, one way to go with this situation.
Yeah.
And as I said earlier, there may be many different routes to the top of the mountain, some more direct than others, but it gets you where you want to go.
And they all end up to one way or another meeting the requirement of fairness in some sense anyway.
Yeah, the summit of fairness. So, I just encourage people to remember that you need to be looking for a settlement, not a surrender. That you need to build a golden bridge over which the other side can retreat with dignity. I ripped that off of Sun Tzu, who used to be a Chinese general. I have very few original thoughts. I steal every.
Well, you've shared some wonderful thoughts with us now, and I have to say that I think we're pretty much at the end of the clock for us. But I want to say thank you so much for this. You are about to face the pointed dagger-like questions of our audience. So if you will sit back and be ready, I'm sure you will be inundated with really interesting questions, and you will give very interesting answers. But again, thank you so much for spending this time with us, and good luck with the crowd.
Thank you. It was a pleasure. Good night, Jim.
Good night.
David, thank you so much for being with us and for providing us with a great look into the art of mediation. So the first question is from David Newman of the Rotary Club of Winnipeg. Mediator speaks of money. Please explain concept of interest-based win-win facilitated getting to yes mediation involving interests beyond money. Please explain the concept of restorative justice. Thanks.
Well, as Joe said in his presentation, the settlement needs to be good for both. So what are the interests of party A and what are the interests of party B? And to get those interests on the table as early as possible. And sometimes people already have the solution to the mediation rather than understanding what it is they really want. And I could illustrate that by saying somebody wants to be financially secure. That's what they really want. Instead, they say, I want $10,000 from this mediation. And as the mediator, you're looking at the pluses and minuses, helping them to understand the pluses and minuses of their position. So instead of going for $20,000, perhaps they want to be reinstated because that might be worth $60,000 a year. Or perhaps they want a good reference as part of the settlement so they can continue to earn more money. There's sometimes some very short-term thinking. Restorative justice, I think of that as restoring the relationships that used to exist or ought to exist. I had a file where an Indigenous family thought they had been really poorly treated at a small convenience store. And it was one massive misunderstanding after another. The store owner had an old hockey injury, and when the teenager opened the door, he bumped the guy's elbow, which caused him paroxysms of pain. The mother, who was paying for some junk food, didn't realize that the sign that referring to the $5 for using credit card, it was not a surtax, it was the minimum amount. So they just misunderstood everything. And when they got what they wanted out on the floor, the Caucasian, the settler family, they just had their eyes opened very widely. And the Indigenous family realized they had jumped to a bunch of unfortunate conclusions. At the end of this mediation, there was actually hugging. That doesn't happen very often, but the relationship was restored. And from time to time, I deal with employers and employees who are still working together, but they've got this complaint. And so I'm working very hard at helping the employee to understand the employer's position and vice versa, so that there is some possibility of a healthy relationship when they return. I often speak about even the most loving couple have communication issues. I love my wife madly, and we're both supposed to be professional communicators, but there have been a couple of times where when she's picking me up from the airport, she's at the wrong door. Or maybe I'm at the wrong door. So misunderstandings are just part of life. So restoration would mean listening to the other person and realizing that the relationship has terrific value. It's got to be more than money.
We have one other question that ended up coming just to me directly. The question is, it seems that much of what you speak of in terms of mediation are useful skills that we can use as Rotarians in our interactions in our clubs and communities. What are the key things we should think about in our interactions?
Well, I would add to that, was it Rod Stewart who sang, "I wish I knew then what I know now," when I was younger? As a husband, I invested a lot of energy as a young husband to help my wife understand what I was saying. And I thought I was terrifically articulate and logical. I did not invest a similar amount of energy into listening and trying to understand her position. So I had said earlier that some really bright lawyers start with, we really want to understand what you think, and we are hopeful that we will help you to understand what we think. But first of all, we want to understand you. And so that's good advice, in my opinion, for anyone in any situation. I must say that I've met a few lawyers, and when I speak to them, they make me think like I'm the smartest guy in the room. and I'm not. But I look forward to seeing them. And I look forward to interacting with them because they give me some of my interests, what I need. We all need to feel respected. And so if you're able to treat everybody with respect and civility, not only is it good for you in a very manipulative sense, but it's also very good for the other person. It's just good all around.
Thanks again, David, with you and Joe and Miller. This was a great evening. And of course, Jim Gillis. We're going to turn it over to Susan Iskra.
Actually, I think we'll turn it over to Gail Marie.
To
Oh,
be fair, it was me that was slated to do this part, Fred, so. I thank you very much to all of our resource people, to Jim Gillis, first of all, for being so diligent about bringing all of these truisms about our four-way test forward to our Rotarians, because it's the mandate, it's our mantra that we live by, and we really need to understand it. So I thank you, Jim. I thank our lawyers, Joe Durker and Ron Miller, for bringing forward what they feel is fair to all concerned within the legal system, and to David Katzman for bringing it forward as a Saskatchewan Human Rights Commission mediator. I really liked what Jim had said when he was speaking to David, different conceptions of fairness. And I think that if we're all aware of that there's not just the one fair outcome, but there is a fair outcome for all concerned. That really spoke to me. So thank you very much to you guys. We really appreciated that. And thank you to everybody that attended tonight. It was great to see our Rotarians out and actually seeing your faces and hearing from you. And David Katzman, did you have your hand up before I carry on?
No, that was my applause sign because I was so pleased with Jim's good work, and I really appreciate your summation. It was bang on.
Okay, thank you, David. And I want to say thank you to our learning and development tech support team. You did a great job tonight. And we should just look forward. Our next evening talk show, it's always the first Thursday of the month, by the way. The next one is October 7th. And the topic is to be determined. So if you have any suggestions for future talk shows, if you would just send them off to anyone on the district governor team, either Dan Sutton, Fred Wright, Sonia Susid, or myself, I would really appreciate that. We're going to go into the fourth part of our four-way test with the November 4th talk show. And Jim is already, I think, preparing for that. So again, if there's any other comments or questions from anybody, before we end our session tonight, I wish you all a good night, and I hope that you all enjoyed the presentation of our four-way test. Is it fair to all concerned? Thank you, everybody.
Thank you.